Thank you so much for coming to our second caregiver workshop. Today we are excited to have Bates Sedek Legal Services here with us. We have Anna Dar and Alan Zenoff, both attorneys with Bates Sedek, and they're going to talk a little bit more about what they do and the services they have in general, so everyone's aware. And then at the end, Elena King is going to speak to us for a few minutes from Ezra Network to talk about her availability and what services she provides. I want to let everybody know we are recording today's presentation. There's a camera in the back. That's why we're using the microphone. We're hoping that this can be useful in the future, or if you missed anything today, that you can go back and record. Yeah. Of course. Yes. Oh, I'm not doing the presentation. I'm just, yeah. Oh, I apologize. Okay. Let me come. Thank you. No, I'm glad you told me because we're recording. We're trying to make this a good presentation. Yeah. Is this better? Okay. Thank you so much for the feedback. So everyone, yeah, that's right. Everyone should have two handouts that are going to be discussed today. If you missed them for whatever reason, they're over at the table. Both of them say Bates Sedek at the top. And then we have a little survey for you to take at the end to give us some feedback. We're hoping that if there's interest, we'll be continuing the workshop series on a variety of topics. If you need the restroom, they're just right out this door to your right. And if you need anything at all, please just go ahead and raise your hand and one of us will come over and help you. You're welcome to help yourself at any time to coffee and some goodies. I left the boxes there just in case you need to check allergies for our kosher snacks. Are there any questions before we get started? Everyone's good? Okay. So I don't know if you want to sit on the other side or...
Let me know if there's too much of an echo. My name's Alan Zenoff. I'm happy to have the opportunity to be here to speak with you about elements, the different elements of caregiving. Did that work where I was sitting? Okay. So I'm sure you're here because you're interested in finding out about different types of estate planning, and we're going to give you an overview of some of the different things that you should be thinking about, whether it's for yourself or someone that you're helping. And I am the go-to person for the Ezra Network. So if you have any legal questions, I'm the guy you call. If I can't answer them, I'll refer you to one of my colleagues or to a different agency. So not only do I do some of this, what I'm going to call estate planning matters. If you have a question about bankruptcy, about renting an apartment, about what benefits you may or may not be entitled to, about a personal injury case, you name it.
All right. Hi. Like Alan said, my name is Anna Dar, and I am the Holocaust Services Elder Law Attorney at Bates Sedek, and I work with a lot of advanced planning issues. So I wanted to come here and speak with you all today. I know you're all caregivers. Slow down. Okay. I wanted to talk to you about some aspects of planning ahead for your loved ones. It's often a tricky subject for many. A lot of people want to avoid thinking about advanced planning and focus on sort of the other view of that. If you do your advanced planning, you're actually taking the burden off your family members by letting them know what you would want. So that's sometimes a good way to start talking about it with those you're caring for, because it really turns the focus around, like they're actually helping you by planning ahead rather than imposing a burden. So I really want to talk about sort of the broader options of what is involved in legal advanced planning options. And how to kind of think about what happens when people start losing capacity and what you can do. We will kind of go over surrogate decision making and the broader terms, and we'll focus a little bit extra on advanced healthcare directives, which is really a hugely important document for everyone. Some other advanced planning options, they go, they depend on everybody's situation, but an advanced healthcare directive is certainly important for everybody. You have a couple of handouts. The one that's titled Planning for Tomorrow, Surrogate Decision Making, is the one that really, if you want to follow along, that's really has kind of the outline of what I'm going to talk about today. So it's a good one to follow along in if you'd like. So before we start, I am curious, has anybody here done an advanced healthcare directive? Oh, excellent. Very good. And have you talked to your loved ones or parents or children about them? Great. So first, it's important to talk about capacity. What is it? What does it mean? So in short, capacity, the sort of legal definition is, it's the ability to comprehend the nature and consequences of your acts and decisions. It's really when people start losing capacity that surrogate decision-making becomes important, because that's when you need someone to step in and make decisions on your behalf. There are different levels of capacity needed depending on what you're trying to do. It's rare that someone has absolutely no capacity to make any legal decisions. And legally, you're always presumed to have capacity. You basically have to be proven not to, for someone to say that you've become incapacitated. And like I said, there's different levels depending on the decision at hand. There's legal definitions of what you have to understand for certain types of decisions. For healthcare decisions, you have to be able to understand the nature and the consequences of the decision, including the risks and benefits, and you have to be able to communicate that decision. Commonly that is, when mom says, well, my daughter helps me make my medical decisions and I want her to keep doing it, that's why I want to sign the document. That's kind of sufficient for an advanced healthcare directive. For financial decisions, it really depends on how important, how big that decision is. If it's a very minor thing, you don't need a lot of capacity, but if you're signing a multi-million-dollar contract, you need a high level of capacity. But like I said, it's all on a sliding scale. Before, there was kind of a presumption that if someone was diagnosed with dementia or Alzheimer's, people would presume that they did not have capacity. But that law changed in 1995 in California, and now, like I said, everybody is presumed to have capacity until you're proven not to. So that kind of leads us into surrogate decision making. And that's, like I said, when someone's lacking capacity, someone else would have to kind of step in and make a decision on their behalf. But what they can or cannot do is dependent on a lot of factors. And, there are no easy answers when someone starts losing capacity, but there are ways to set up documents to help make the process a little bit easier. There's two types of surrogate decision making. There's informal and formal. And they're kind of what they sound like. Informal surrogates are usually a practical setup. It stems from a previous relationship, like a mother and daughter. Daughter might help mom take care of her banking, take her to the bank and talk to her. Family members kind of stepping in and helping out. And if the decision is just something routine and simple, then it can work for a very long time. But sometimes it doesn't, and then you need to have a formal surrogate, and that's someone that has been appointed either by the client, a durable power of attorney for finances. It's a legal document. It's revocable, meaning you can take it back at any time or change it. It has certain limitations. It doesn't stop someone from making bad decisions. If mom has a power of attorney, she's completed one, daughter is her agent, mom can still make her own decisions. Nobody can overrule that. If she is making bad choices, like, spending money on the Jamaican lottery scams or something like that, daughter can't stop her with the power of attorney for finances. So it has limits. A good thing about the power of attorney for finances is when you appoint an agent, they have a fiduciary duty to only act in your best interest for you. You can make a power of attorney for finances. It can be effective immediately, or, which is very common, it can have springing power. That means you say, I'm giving my daughter the power to be my agent and take care of my finances, but only if I lose capacity. So while I'm fine, she has no power to do anything. But once a doctor determines that I no longer have capacity, then she can step in. So that's really a forward planning tool that may never be used, but it's good to have in place. And I didn't put it on here, but you can have multiple agents for this document too. You can have two people who have to work together. You can have one person then the other, or you can just have one. And I am gonna let Alan talk a little bit about trusts. Now, trusts is another really good planning tool for the future. It's not something that SADC can help with. It's a more complex document that you need an estate attorney to complete, but it's a great way to plan forward as well. So I'm going to let Alan go ahead and talk about that.
Do any of you have a trust? Great. A trust is a really neat mechanism for you and your families, because a trust avoids having to probate an estate. In other words, you don't have to go to court. So for those of you who don't have a trust, the way it works is that you put everything you own into the trust. For example, if you own a home, it doesn't matter if it's paid for or you're still paying on a mortgage. You actually convey the property. By convey, it means transfer the property into the trust. The trust becomes the owner of the property. You have the power to direct the trust what to do. So if for some reason you decide that you don't want the property in trust anymore, then you convey it out of the trust. It's a great mechanism. Bank accounts generally can go into the trust as well, and any other real or personal property can go into the trust. So the trust becomes the title holder, and you then direct the trust, and upon your death, the new trustee now can direct the trust what to do, which should generally be to distribute the assets. Question? Right. No, that does not need to go in. Sure. The question is, if you have a payable on death account at the bank, does that need to go into the trust? No, it does not need to go into the trust. It does not be, yeah. So a payable on death account is established upon your death, okay? It would not go through probate. If you ever heard that Medi-Cal, if you're on Medi-Cal or you're caring for someone on Medi-Cal, will not go after, can't go after the trust, which will hold title to the real estate for money that expended for your care. It's about 1.5 years old, the law, and so that's another benefit of the trust. Yes. Okay. So, do you know what Medi-Cal is? Sure. Do you know what Medi-Cal is? Okay. Okay. So Medi-Cal is prohibited from pursuing recovery of the expenditures that they make for your health if your real estate or any other property is held in trust. It was a new law that was passed a little more than 1 year ago. If you didn't have a trust, then Medi-Cal could put a lien on your house and try and collect the money that way. The money becomes due on your death. Yes. You pay a lawyer to prepare the trust. It's a document, multiple pages long, and basically, let's say you've named a beneficiary to eliminate that person as a beneficiary. No opinion, maybe it'll hold up, maybe it's good. I just think that you'd be better off paying an attorney to do it because you know it's going to be done right. I'm sure it's expensive, but you know, if you own a home and it's paid for, maybe it's worth it. I don't know. Yes. Okay.
Okay, this is a very specific Medi-Cal question. When there's impoverished spouse rules under Medi-Cal. When one spouse is in a nursing facility and the other spouse is not on Medi-Cal, they can keep a much higher part of income and assets than if they were both on Medi-Cal. That's kind of the short of it. And your question was, if you, as you're not the spouse, the non-Medi-Cal spouse, if you were to pass away, but your husband was still in the Medi-Cal facility, how would that look? And it's hard to say, but I believe, you would be out of it would just be him on Medi-Cal. So all the impoverished spouse provisions would just disappear. He would then own the home again, so that would be the issue. Unless, again, you had a trust. The rule really is, before, the rule used to be Medi-Cal could go file Medi-Cal recovery claims against any assets that were left after the Medi-Cal spouse passed away. There are provisions to protect the spouse. If the spouse lives in the home, they'll wait until the spouse also passes away to recover, but the children wouldn't get the home. But now the new rule simply says Medi-Cal will only recover against things that pass through probate, meaning they pass with a will or for slightly larger assets. So a trust takes things out of the probate process. So Medi-Cal will only recover against the things that go through. So that's kind of really the simple way that it works now. Okay. Okay, we have one more question on trust, and then I think we'll move and maybe do a little more trust talk at the end, because I know that's a very interesting conversation. I think, and I won't go through the whole question right now. I think the question was a very specific issue of a townhome being owned by two separate people and half of it possibly in trust. I think maybe this is something we can talk about afterwards because I think it's a little bit complicated to talk about in the group, but I'd be happy to talk to you about it afterwards and see if we can.
There's another legal vehicle that perhaps can be used to eliminate the problem that you're speaking about, and we'll be happy to talk to you about that.
Okay, so we're going to move on from trust, but like I said, we'll be here after if anybody wants to come have a one-on-one, or we can talk more in the group after. I'm going to go through wills, and I know a lot of you are familiar with what wills are. It's just a document where you determine who should get what of your assets and who is in charge of distributing them. Betsedec only does one type of will right now, unfortunately, the California statutory will, which is a very simple will. It's a statutory fill-in-the-blank will form. The benefits are courts recognize it. It's very simple, very unlikely that there would ever be any issues down the line with the statutory will. But like I said, it has limitations. It's really for smaller, simpler estates. Some of the limitations are you can't unevenly divide your assets. Like if you have two children, you can't give one of them 2/3 of your things and the other 1/3. It has to be even, so half and half. And also you can't make specific gifts. Like if you have a painting or a diamond ring you want to give to your granddaughter, you can't say that in a statutory will. You can just say all my assets to all my children divided equally. So it's good to have, but if you have a slightly more complicated estate, you would want to go with another option, either an attorney-drafted will, which is probably the best option, especially for complicated estates, and there's also the holographic will, and that just means a handwritten will, which is legally totally effective, but it's very easy to mess it up and to create problems down the line. And you would never know it was going to create problems because none of those problems surface until later. So holographic wills are effective, but they can be risky. If there is no will, then a person, it's called dying intestate. And there is a misconception. A lot of people believe that dying intestate means the state gets everything you had. But that's not true. It's certainly not in California. We have a order of succession here. So it's basically, there's a legal order of persons who would inherit if there is no will in place. But going on the, our big focus about doing advanced planning, especially for yourself, is to retain control, to make your own decisions about what's going to happen in the future. So certainly a will is one way to do that, instead of leaving it up to the state in the order that they think is correct. So it's certainly empowering in its own way to have a will ready. Now, just a couple more things on financial surrogate decision making. Two other very common things are the Social Security representative payee option. People call it rep payee for short. It just means, say somebody's only income is Social Security, daughter's helping mom out, daughter can go into the Social Security office, fill out a rep payee form, and she can then manage mom's Social Security money. Instead of going through the whole process, of which maybe you don't even need a power of attorney for finances when that's the only income and it's just about managing that. Often nursing facilities and places like that also become representative payees, so the check goes straight to the facility and that pays for the person's stay, and then maybe there's no need to, she can only use that money for him in his best interest, not for herself. So it's kind of a level of trust issue. If there's not 100% trust, then joint accounts are not a good idea. And even if there is 100% trust, it's good to be aware that there could be some risks. Financial power of attorney, which is a simple document. It just, it has to be notarized. There is it's a little more involved. So we're going to move to surrogate decision making on the healthcare side. And here, the big important document I mentioned in the beginning is the power of attorney for healthcare. It has a lot of names, so you've probably heard of it, and maybe another name. The Advanced Healthcare Directive, Advanced Directive, Living Will, Healthcare Proxy. And it's a legal document with two components. It allows you to choose and appoint an agent or multiple agents who can step in and make healthcare decisions on your behalf, either if you become unable to make decisions for yourself or immediately if that's what you want. And you can also, in that document, provide healthcare instructions. And they need to be clear instructions, which would then be used by the healthcare provider if there is no agent or if the agent is not available. How does it work? Well, it's important to mention that one of the most important parts of the advance directive is the conversation between the person who is making the directive, that's called the principal, and the person they're choosing as an agent, the person who's going to make decisions for them. Because if that conversation doesn't happen, if the agent doesn't know what the principal wants them to do or what choices they want them to make down the line, then it's not helpful. Then it's hard for the agent later because they will have to guess and hope they can figure out what the principal would want them to do. Generally, the agent has the same power the principal would have. So any healthcare decisions, anything ranging from authorizing sharing medical records all the way to ending life-sustaining measures. This power can be limited, but generally it's a very broad power. And like I said, generally the agent only has the power once the principal becomes incapacitated, and that would be determined by a doctor or by the person's physician. But you can make it effective immediately if that's something that would be helpful. That's kind of a person-to-person basis. If you want, if a person wants their son to step in right now and talk to the doctors on their behalf, deal with medications, all those things, you can certainly make it effective immediately. Everyone. We all should have one. It's not a fun, and it ended up being a 15-year legal fight between the parents and the husband. And it was, if there had been a directive, none of that would have ever happened. There was new laws drafted. I think there was 4 legal cases involved. That one is obviously extreme, but not having one can certainly lead to a lot of family strife and stress for everybody. We had a client once. Her terminally ill son completed a directive, and she said her words were that having it was like a gift to the family, because she felt completely empowered to do what he wanted her to do, because his writing was on the paper. He was telling her, this is what I want you to do, and she felt at peace with the hard decision she had to make, and she could do it, and she felt like she was doing exactly what he wanted. She wasn't sure she could have if she didn't have that piece of paper telling her what he wanted. So it's very important. And in most cases, it'll never be used, but it's good to have, because it's just a really central part of planning ahead. Now, there are some other options for healthcare for surrogate decision making. You've probably heard of the DNR form and the POLST, the Physician's Orders for Life-Sustaining Treatment. Neither of these are legal documents, so that's not something that we do. That's something to talk to your doctor about if that's something that's suitable for the person you're caring for or for yourself. Of course. The question was, do you need a POLST if you already have a healthcare directive? And those two they're very different documents. They do different things. And normally, a POLST would only be completed for someone who is sort of at the end of the road. A doctor would normally not complete a POLST for someone who is generally healthy and maybe suffering from some illness, but it's more for sort of terminally ill situations. And a POLST actually references an advanced healthcare directive, so they don't do the same thing. A POLST also provides directions to emergency workers, so you can have one. If you have a POLST, I don't know if you've seen one, it's the bright pink form. You can put it on your fridge. If paramedics came into your home, they would see it and they would follow it. An advanced healthcare directive has nothing to do with sort of emergency. It's more treatment down the line in the hospital with a doctor. So they're just different documents. Now, when there is no surrogate, or when one of those informal surrogacies that people have set up, when it doesn't work anymore, or even when the formal surrogacy doesn't work anymore, like in the example where mom continually gives away her money to a Jamaican lottery scam, and you know it's wrong, and you have power of attorney, but you cannot stop her, then really the only option is a conservatorship. I don't know if any of you have heard of this process. It's basically guardianship for an adult. It's really powerful, and it's a lot of work, and it involves court involvement for the rest of the person's life. It's costly. It basically involves the court stepping in, taking autonomy away from a person and putting it in someone else's hand. So it's a very big deal. Sometimes it is necessary, but a big part of doing some of this advanced planning, like financial power of attorney and advanced healthcare directive, is to avoid this. This is also a big part of what was going on in the Terry Schiavo case. Both the parents and the husband filed for conservatorship over her, and they battled that in court for many years. So it's something that can be necessary, but oftentimes it can be avoided. We mostly deal with, Betzetic does some conservatorship work. There's different kinds of conservatorships, but the two most common ones that we work with is the conservatorship of the estate and conservatorship of the person. It's basically financial and health. Other planning, I just want to mention, these are other ways to plan ahead, which are certainly helpful for family members. You know, prepaying for a burial, selecting a cemetery, or pre-arranging funerals and services. And that is the end of that Fast and Furious presentation. And we will have some time for questions right now, if anybody has any questions.
As far as other planning goes, have you heard about, or do any of you have long-term health care insurance? If you're at advanced age, it's pretty expensive. About 10 years ago, I decided to purchase a long-term health care policy. So between my Social Security and what I will get under my long-term health care insurance, my kids won't be burdened financially with dipping into any assets that I might own. So I'm going to go to, if I go into a nursing home, I've got 3 years of care that it's going to be taken care of between long-term health care and between my Social Security. So if you're caregiving for someone, and it costs $166 a month. If you, and that's a policy I got about 10 years ago. So it's another option to think about, yes. Right. I don't know. I suspect not. I think you're a higher risk. We couldn't get one for my wife because she has fibromyalgia, and they wouldn't write a policy for her. Well, you'll pay a long time, but it'll be much less expensive.